Welcome to today's session on the admissibility of evidence in criminal litigation. Today, we aren't just summarising rules. We are conducting a forensic examination of the structural filters that define the criminal trial process. Admissibility is not merely a box-ticking exercise. It is a fundamental mechanism that balances the prosecution's power against the defendant's right to a fair trial. Mastering these rules is what separates a routine practitioner from a strategist who can dismantle a prosecution's case before it even reaches trial. We begin with the court as an active gatekeeper. Evidence must pass a primary test, relevance. Does the evidence have a logical relationship to a fact and issue? If it does not, it is automatically inadmissible. But even if evidence is highly relevant, the court must subject it to gatekeeping filters of Police and Criminal Evidence Act 1984, commonly known as PACE 1984, the Criminal Justice Act 2003, and the Criminal Procedure and Investigations Act 1996. We must evaluate every piece of evidence against the statutory threshold and ask, does this evidence comply with the procedural rules that uphold the defendant's right to a fair trial, or does it violate the principles of due process? This requires a granular understanding of how statutory law and common law interplay to safeguard the court's integrity. Additionally, at the heart of the framework is the overriding principle of fairness, which dictates that every trial must not only be lawful, but must also satisfy the requirements of a fair and balanced process for all parties involved. Confessions are often described as the gold standard for the prosecution, but they are subject to the strictest safeguards under Section 76 of PACE. Oppression is not just physical violence, it includes psychological tactics, bullying, or persistent questioning designed to break a suspect's will. The unreliability test under Section 76(2)(b) is even broader. It encompasses any conduct, including police promises, failure to provide rest, or exploiting a suspect's mental vulnerability. The prosecution bears the legal burden to prove beyond reasonable doubt that the confession was not obtained by these methods. This is a mandatory rule, not a discretionary one. If the prosecution cannot meet this high burden, the court must exclude the confession, regardless of its potential truthfulness, to uphold the integrity of the justice system. Section 78 is your discretionary fairness lever, applicable to any evidence, not just confessions. This requires a two-stage analysis. First, identify the breach of the PACE codes of practice. Was it a significant and substantial departure from the required standards? Second, establish a causal link between that breach and the resulting unfairness. You must demonstrate that the breach isn't a mere technicality, but an error that has compromised the reliability or integrity of the evidence. If you can show that admitting the evidence would bring the administration of justice into disrepute or jeopardise the fairness of the trial, the judge has the discretion, and indeed the duty, to exclude it. Hearsay is an out-of-court statement offered to prove the truth of what it asserts. Because the maker is not present to be tested, it is generally inadmissible. You must navigate the specific statutory gateways under the Criminal Justice Act 2003. Firstly, for absent witnesses under Section 116, you must prove the witness is either dead, ill, afraid, or cannot be found after all reasonable steps have been taken to find them. For business documents under Section 117, you must verify the document was created in the course of trade or business, and that the person providing the information had personal knowledge. If you are opposing hearsay under Section 114, Interest of Justice test, your argument should focus on the probative value versus the potential prejudice. If hearsay is the primary evidence, you must argue that it is too unreliable to safely support conviction under Section 125. Bad character is inadmissible by default to prevent the jury from forming a biased view of the defendant's past. To admit this, the prosecution must fit it into one of 7 gateways, such as propensity to commit offences or propensity to be untruthful. You must apply the Hansen test rigorously. Is there a genuine propensity, or is the prosecution just using stale or irrelevant convictions to inflame the jury? Propensity isn't established simply by a criminal record. It requires evidence of a tendency to act in a certain way. If the admission would be unjust, perhaps because the convictions are too remote in time or not truly representative, you must invoke Section 103, subsection 3, to argue that the probative value is substantially outweighed by the prejudicial effect. When the case hinges on a disputed visual ID, Turnbull is the mandatory protocol. The advocate mnemonic is just the start. You must cross-examine the witness on the entire context. Was there high stress, poor visibility, or a short duration of observation? The Turnbull guidelines state that a witness can be entirely honest yet fundamentally mistaken. If the quality of the ID is poor, for instance, a glimpse of the stranger in the dark, cluttered conditions, the judge has a legal duty to withdraw the case from the jury and direct an acquittal. You must force the court to recognise that the reliability of an ID is fundamentally different from the sincerity of the witness. Submission of no case to answer. This is your procedural stop button, used at the close of the prosecution's case. In this situation, you apply the Galbraith test. Under Limb 1, there is no evidence that the offence was committed. Under Limb 2, the evidence is so weak, vague, or inconsistent that a reasonable jury properly directed could not convict. You must explain to the judge that this isn't about witness credibility, which is for the jury, but about the sufficiency of the evidence as a matter of law. If the prosecution's case is fundamentally defective, you have a duty to end the trial immediately, saving your client from the unpredictability of a final jury verdict. The duty of disclosure. Disclosure is the bedrock of equality of arms. The prosecution has a continuous duty to disclose unused material, anything that could undermine their case or support yours. Be surgical. Serve a precise defense statement that defines the exact issues in dispute. If the prosecution is holding back CCTV footage, witness notes, or information about other suspects, you must use this definition to force disclosure. If they fail to provide this material, you must be prepared to make a formal application to the court, arguing that the non-disclosure is an abusive process that denies your client the right to a fair trial. Finally, to summarise everything we have covered today, admissibility is not about hidden truths. It is about playing the rules of the game. Whether you're scrutinising a confession under Section 76 or challenging an ID under Turnbull, or forcing disclosure under the CPIA, you are ensuring the trial remains fair. Mastering these rules ensures that you're not just participating in the trial, but directing it. I'd like to thank you all for getting to this part of the video and for listening in today. It's greatly appreciated. If you have any questions at all, please put them down in the comment section and I'll be happy to get back to you.